Hello everyone, so this is recording 2 for the topic of occupiers liability, and in this session we're going to look at claims for trespassers against occupiers. So before we start, go back to basics and think about who is bringing the action and who is the action against here. So who would be the claimant and who would be the defendant in an action for occupiers liability. So hopefully you're thinking along the lines of the trespasser being the claimant, and if we link back to our criminal module where we first came across the term trespasser, in burglary, what do we mean by trespasser? And this is a person who exceeds permission of the owner. So if you become a trespasser on land, you are essentially exceeding the permission to be there. Of course, the defendant would be the occupier, and the general rule from the 1957 Act in determining who is an occupier would be the same. And if you refer to Wheat and Lack Co., this could be quite a wide meaning. So anybody who not just owns the property, the proprietary owner, but any person who is also in control at the time as well. So as a bit of background, and in class we talked about whether it is actually fair that trespassers would be able to bring an action against occupiers, and many of you thought it wasn't, and actually historically the courts and Parliament would agree with you. Traditionally there was no duty owed to trespassers at all, not even to children. You may remember a previous precedent that we learnt in your judicial precedent module, Addy and Dumbreck, and in this case the House of Lords prevented the parents from claiming compensation where they actually lost their 4-year-old child who was injured and killed whilst trespassing on somebody else's property. So that was obviously quite a harsh decision, and this was made by the court on the basis that the child was a trespasser and shouldn't have been on the land at that time. But we then fast forward approximately 50 years and we get to a key case which actually changed the way the courts and Parliament viewed this area entirely. So British Railways Board, or BRB for short, against Harrington. So this case went all the way up to the House of Lords as it was then in 1972. And if you look at the facts here, this was similar to Addy v Dumbreck actually, where a young child was seriously injured, didn't die but seriously injured whilst trespassing on somebody else's property. And if you read the facts partway down, there's reference to the defendants of British Railways Board being aware of a gap in the fence which had been present for several months and they hadn't done anything about it. Now, the House of Lords acknowledged that in making a decision in this case, it would change previous precedent, as stood Addy and Dumbreck, and they decided to overrule that previous decision using the practice statement. And hopefully you can remember the year that the practice statement power was confirmed and given to the House of Lords. They used this power to overrule the previous decision, and the ratio of this case was that occupiers now owe a reasonable duty of care to trespassers. Now, of course, on the facts you would think that this only applies to children, but in actual fact the Law Commission decided to research and prepare a report on this area, and Parliament legislated in 1984, the year I was born, on this, not just limiting the law to children but also to adults. So what we have now is liability imposed on occupiers where even adults are trespassing. skipping to evaluation, you may feel that this area is unfair, and there may be reasons for that, and we will discuss those when we come to looking at the potential essay questions. What I would say at this point is that it's not entirely easy to claim in this area. It's much easier to claim under the 1957 Act. So what we'll do is carry on and look at the requirements for this. The task I want you to do, and I'd like you to pause this recording in a minute, is to look at the law. So I've given you a straight cutout from the legislation online of the main sections under this Act that you need to be aware of. And in your booklets there is a slide where you can summarise the key pieces of law in your own words. So can you do that now, please? And I will run through it in a second. So if you can pause that now, that would be great. So having completed that, so the sections under the Occupiers Liability Act, what we actually have is Section 3, so your slide should actually say Section 3 to start. What this section says is that an occupier of premises owes a duty to another if, and there are some conditions here. Firstly, he is aware of the danger or has reasonable grounds to believe that the danger exists. Or secondly, he knows or has reasonable grounds to believe the other, as in the trespasser, is in the vicinity of the danger concerned, or that they may come into the vicinity of the danger. So thinking back again to a previous unit, lawmaking, what do we mean by in the vicinity? You may remember we looked at a case which said that this means in or around the area. So if as an occupier you have reasonable grounds to believe that the trespasser is in or around the area, then you may owe a duty to that person. And thirdly, the risk is one against which in all the circumstances of the case the occupier may reasonably expected to offer the trespasser some protection. And this part is really important. I would like you to underline or highlight the word reasonably. This is all about what is reasonable. Is it reasonable to expect to offer a trespasser protection? And if we think about children, it may be more reasonable. If you are aware that children are trespassing on your land, then it may be entirely reasonable to expect you to offer some protection to those children to avoid serious harm or death. Section 4, the important part here is that it actually sets out what the duty is, and here the duty is to take such care as is, and we've got this term again, reasonable in all the circumstances, to make sure that the trespasser does not suffer injury on the premises by reason of the danger concerned. So it is a reasonable duty of care owed here. And then finally under 5, essentially what 5 and 6 give the occupier are defences, and hopefully you've read that, taken that from this. So an occupier may discharge their liability if they give a warning of the danger, but of course that warning, if we think back to looking at warnings under the 1957 Act, that warning must be able to be understood, it must be clear. And under Section 6, perhaps there is consent to the risk. So if you trespass, you ignore the warning, or you understand the danger, are you consenting to that? So those are the main requirements of the legislation. We have where a duty would be owed, what the duty is, and what may discharge the duty for those 3 main points there. So hopefully you've got those summarised, and we will have a look at those in class. So that's the key law, but as I said to you before, because this is a duty reluctantly owed in relation to trespassers, there are quite a few limitations. If you look top right on this slide, a major restriction or limitation is that actually trespassers can only claim for injury or harm that they suffer. They cannot claim for damage to property, so that's one difference there. The other limitations that I've set out here will really depend on the facts of the case. So let's just have a look through these now together. So if the danger is obvious, then the occupier will not be liable. If you look at the authority here, Ratcliffe and McConnell, so a 19-year-old student climbed the fence of his open-air college swimming pool at night and dived into the pool, hitting his head on the bottom. He was seriously injured. Now, taking into account the age, the fact that this person was a student at this college, so they will have been aware of the surroundings of the pool. They weren't a complete visitor or guest. It is foreseeable that the danger would potentially be obvious here. The next one is taking into account the time of day and time of year. So visibility, weather, etc. may have an impact on the trespasser's ability to identify a risk. But equally, this could work the other way as well. So Donoghue against Folkestone Properties, so the claimant, being Donoghue, was injured when he was trespassing, diving into the sea in a harbour. He hit a grid pile used for mooring boats, which would have been visible at low tide, and the incident occurred at midnight in the middle of the winter. So actually, it would have been more difficult to see that this could have been more of a risk. Is it fair that we would hold an occupier responsible for this? You need to ask yourself that question. How would the courts deal with this type of risk and these facts? Limitations we could think about. So, and number 3 relates back to reasonableness. We do not expect occupiers to spend lots of money in making premises safe from obvious dangers. If you think back to the Laverton and Kaya Pasha Takeaway Supreme case that we looked at when learning negligence, the courts did not expect the takeaway to do any more than mop the floor from rain and fit slip-resistant tiles. The fact that they had done that, they had done in the court size more than what would be reasonable to stop people slipping over and injuring themselves when it was raining outside. So it's really about reasonableness here and practicality of precautions taken. So the key case here is Tomlinson and Congleton Borough Council. So the claimant, being 18 years old, was seriously injured when diving into a prohibited lake owned by the council. The council were aware that the water was dangerous and posted warning signs. The work on the lake was delayed due to a lack of funds. The Court of Appeal ruled in favour of the claimant initially, but this was then reversed by the House of Lords. So in actual fact, Congleton Borough Council won this case, and it was deemed that they had completed enough requirements in order to try to protect people from obvious dangers. And you might want to think a bit about what they had done. Obviously, the warning signs were sufficient under Section 5. Number 4 relates back to one of the main requirements, really. Does the occupier have a reason to suspect the trespasser is, as the legislation says, in the vicinity? If they do not have any reason, and it is not reasonable to expect that the trespasser would be in the vicinity, then they will be less likely to be liable. The case here, being Higgs and Foster, was actually about a police officer who had gone onto the occupier's premises to carry out surveillance. Now remember, sometimes a police officer entering premises could be a lawful visitor under the statutory right, but it really depends on what permission they have to be there. So for this case, it's just worth noting that the police officer was deemed to be a trespasser, so they obviously didn't have statutory permission to enter. So the occupiers knew that there was a pit which was a potential danger to anybody walking nearby it, and of course the police officer was injured falling into this pit, but the occupiers were not liable because they could not have anticipated the officer's presence. So quite an interesting case there, which on an evaluation point seems to rule against the usual rules in relation to emergency and civil services. And then we have number 5, and this relates to, again, the legislation. We can link it back. The occupier will not be liable if they are not aware of the danger or had no reason or had any reason to suspect the danger existed. And the relevant case here is Rind against Astbury Water Park. So the occupier didn't know of a submerged fiberglass container resting on the bottom of its lake. The claimant, Rind, was injured when he jumped into the lake, but he ignored a notice stating private property, strictly no swimming. So here what we have is a clear warning sign, despite the occupier not knowing of a specific risk, and of course that was enough to have prevented them being liable. So really it is looking at each case on its own facts and deciding whether the occupier has done enough to prevent liability. And it would be worth, in the same way as you do the breach of duty factors, it would be worth actually using these 5 potential limitations and applying them in any scenario once you've identified whether there is a prima facie duty of care owed. Going on to child trespassers here, obviously this area of law coming about because of child trespassers and the risks involved. If you remember one of the judges summing up their decision in the key case here, Harrington, they did state that children are more likely to trespass nowadays. There are more built-up areas, we have a denser population, and therefore there are going to be more risks. So it's really important that the courts take note of this and protect children. So we've got a key case here, Cone against Coventry Healthcare NHS Trust. So here we've got an 11-year-old who climbed a fire escape on the exterior of a hospital to show off to his friends, and he fell. He appreciated the danger, it was deemed in evidence, and it was not the state of the premises that were at fault, and the hospital was deemed not liable. So actually what we have here is a court who, despite this being an 11-year-old boy, trying to determine whether he actually appreciated the danger on the facts. So remember, occupiers, even in relation to visitors but also to trespassers, do have a duty of care to children. But in terms of if you were a visitor, you would have a greater duty of care to a child than if they are a trespasser. The rules of that duty only being reasonable applies to child trespassers as well as adults. So what I'm trying to say to you here is that the courts still have the primary reasonable duty that is under the legislation here, and they apply it to the children as they would to adults. So on the facts here, they believed that this boy understood and appreciated the dangers. And given that you can be held responsible for a criminal offence from the age of 10, this would make sense that over 10 you would be more likely to understand the dangers than if you were under 10, for example, as was the case of Harrington. So, in terms of defences, the same defences are available to trespassers as they are to visitors. So we have contributory negligence here, and remember this is a partial defence where the court, if they deem this is relevant, will reduce the damages by proportion under the Law Reform Contributory Negligence Act 1945. They will reduce the damages by the proportion of contribution. Consent, otherwise known as valenti here, is also allowed, and if you remember we made note of this under section 6. Where this will be relevant is if the trespasser is deemed to have appreciated the risk, and that's not just the nature of the risk but the degree of harm as well, rather than just knowing that there is a risk in existence. So this really is or involves a forensic look at the facts. What did the claimant understand? What did the trespasser understand about the risk? Was there a serious risk of harm? Was there a low risk of harm? And the courts will take this all into account. And finally, a warning could be a full defence, as consent could be as well, especially if the trespasser is an adult, because of course you would expect an adult to have more of an understanding about a warning. So whether a warning is applicable or not under section 5 will depend on their age and understanding. A child will be less able to understand a warning, but it must be in clear terms. So a warning could reduce damages, certainly from a judge's point of view, if there is a warning, even if they believe that doesn't amount to a full negation of liability, that may certainly be taken into account. It could reduce damages, or as it can be, a full defence, like in Tomlinson, if it actually takes steps to make the claimant safe. And you see what I've put here is another case that you could use, Westwood against Post Office. Sorry for the triple Fs there. So the claimant, an employee of the Post Office, was injured when he entered an unlocked room as a trespasser. The room had a notice which said, "Only the authorised attendant is permitted to enter." It should have been locked. The Post Office was not liable. So that warning was enough to negate the Post Office's liability. So what we have on the following slide is space for you to summarise, and by all means you can wait until we get to the lesson and we can summarise together. But I'd like you to make sure you read through your notes and you have made additional notes where possible with me on this recording. Do in the lesson is have a look at this scenario here, which comes from a specimen exam paper and requires you to identify first of all whether Bilal is a lawful visitor or whether he is a trespasser. And if I last slide, this is a basic overview of how you would set out a scenario with occupiers liability. It's not always going to be the case that an exam question will tell you which area to consider. You may need to firstly identify whether the claimant is a visitor or a trespasser before you go on to deciding which act applies. And of course we need to understand who the claimant is, who the defendant is, and whether the defendant is an occupier of premises. So you identify your parties first, identify whether the claimant is a visitor or a trespasser. Obviously make note if they're an adult or a child, because certainly in terms of the 1957 Act, if the claimant is a child, that will make a big difference. And then we go into whether there is a duty owed, what the breach is, and whether there are any defences. So we have our 3 stages again to apply. So you could use this basic flowchart here write it out on A3 or A4 paper and put your law around it. So the law from this booklet, you can write on it to give yourself an overview. Bring that to the lesson and we can do some practice of application here. And just note, bottom right, a lawful visitor can become a trespasser if he exceeds permission or enters a prohibited area. And that is exactly the same as we've studied in the criminal law module, where you could be invited around somebody's house and be a visitor, an invitee, and if you go into a prohibited area or an area where you do not have permission, you then become a trespasser. The rule is exactly the same in law here. So I hope that makes sense to you, and what we will do is we will have plenty of practice in the lessons. There are some more scenarios further on in the booklet that we can practice, and then hopefully you will be more confident in this area. If there are any questions, please make a note of them and you can ask me in the lesson time. Thank you very much.